morning, and thank you for joining us. We're going to spend some time today talking about obtaining a green card based on employment. In particular, we'll focus on obtaining a green card through the PERM process. A few things before we get started. Scott Legal PC is a full-service immigration firm, but we focus on a number of different types of visas, including green cards through employer sponsorship. We will continue our webinar series, doing at least 2 webinars a month on different topics. And at the end of this webinar, we'll send out a few things. One is a PowerPoint that you'll see today. Another is a PERM guide, which is a comprehensive guide going over the PERM process. And you'll also receive a link to where you can sign up for additional webinars. My name is Kelly LeGrand-Wiener. I'm the managing attorney at Scott Legal, and I will be your presenter today. I regularly process employer-sponsored green cards as part of my immigration practice. If you have questions as we go through the presentation, please send them through the chat box. We will either get to them during the presentation or towards the end. There'll be time for questions. And finally, the webinar will be recorded and made available on demand. So before we dig into the PERM process, we'll talk a little bit about just generally how do you obtain a green card in the United States. So there's a few different ways. Not all of them are listed here, but some main ones that we put on the slide. So for family-based green cards, if you have an immediate relative in the United States, there's always a green card available for you. So if you marry, a U.S. citizen, if you parent, child, anyone in the immediate relative category, you can obtain a green card through that method. There's also preference categories, which are for family members who don't qualify as immediate relatives. So for example, brothers or sisters of U.S. citizens, spouses and children of legal permanent residents, and other people in those categories. Let's turn to employment-based green cards, and we'll talk a little bit more on future slides about each of these green cards. So the EB-1 Extraordinary Ability Green Card for people who have, reached the very top of their field and achieved sustained national or international acclaim. There's the EB-2, which has a few different categories. One is the National Interest Waiver, which we'll talk a little bit about in a future slide. And the other is kind of the PERM process. So if a company sponsors you for a green card in the EB-2 category. EB-3 is available for professionals or skilled or unskilled workers in the company sponsorship area. So that's where you would go through the PERM process. The EB-4 is available for, religious workers. And then there's the EB-5, which is available for people who have invested a particular amount of money into the United States and created a certain number of jobs. So in particular, the employment-based green cards that we're going to focus on, today are, EB-1, EB-2, EB-3, and EB-5. Sorry about that. So for the EB-1, as I mentioned, this is a green card for people who have reached the very top of their field and can show extraordinary ability in the sciences, arts, education, business, or athletics through sustained national or international acclaim. This green card category is appropriate for people who have reached the very top of their field. They can either show this through a one-time achievement, such as a Pulitzer Prize, a Nobel Prize, an Oscar, an Olympic medal, and evidence that they'll continue working in their field of extraordinary ability in the United States. Or more commonly, people will show it through kind of meeting 3 criteria, to prove that they have extraordinary ability. So this would be kind of evidence of, lesser but still significant national or internationally recognized prizes. So maybe there's no Pulitzer, but there's other very significant prizes within the industry that you can point to. If you have membership in associations in the field which demand outstanding achievements of their members. If there's published material about you in professional or major trade publications or major media. Evidence you've been asked to judge the work of others individually or on a panel in your area of expertise, evidence of any original scientific, scholarly, artistic, athletic, or business-related contributions, Evidence of authorship of scholarly articles in your field of expertise that have been published in major media or professional publications. Evidence your work has been displayed at artistic exhibitions or showcases if you're in the arts. Evidence of performing a leading or critical role for an organization with a distinguished reputation. Evidence that you command a high salary, in comparison to others in your field, or evidence of commercial success in the performing arts. So, you'd need to really reach an extremely high level and have lots of documentation to prove it to meet this category of EB1. When we look at the EB2 National Interest Waiver, this is for people who, as a threshold requirement, they must have either a master's or higher degree, or can demonstrate exceptional ability. And for the National Interest Waiver part of the application, they show that they merit a waiver of the job offer and labor certification because it's in the national interest of the United States to do so. So to qualify, there must be a proposed endeavor that has substantial merit and national importance. You must show the applicant has the ability to advance that endeavor, and that on balance, it would be beneficial to the U.S. to waive the requirement of the job offer and labor certification. So now we'll look at the EB2 and EB3 categories in the PERM context. So for these categories, very commonly used by companies to apply to sponsor their employees for green cards. A full-time job offer is required. And the company must test the U.S. labor market to determine if there are any willing, qualified, and available U.S. workers for the position. If none are found, then the labor certification can be sent to the Department of Labor. If it's certified, then you can proceed with filing the I-140 petition, where the applicant shows they meet all the criteria for the job and the employer shows they can pay the prevailing wage. And then you can go ahead and file a green card petition once an immigrant visa is available to you. When we look at the EB5, this is where you're going to get a green card through your investment in the U.S. and creation of U.S. jobs. We regularly do EB5 webinars that go into much more detail about the EB5. So I would recommend signing up for one of those if you're interested in the EB5. There was a pause in the Regional Center program, much earlier in 2022. That pause is now gone. So both the direct investment and Regional Center EB5 programs are available for green card applications. You must invest either $800,000 or, $1,050,000 and create 10 full-time jobs. And there's, obviously some more nuance to that. And I would encourage you to sign up for one of our EB5 webinars to learn more about that. All right, so what is the labor certification process? What is the PERM? So when we look at this process, you can either qualify under the EB2 or EB3 categories. PERM refers to the process where a company sponsors an applicant for a green card. The company tests the labor market by placing advertisements and actually interviewing applicants. If no willing, qualified, and available U.S. workers are found, then the company can file the I-140 petition and then a green card. The EB2 category is available to people with advanced degrees or equivalent. So the equivalent to an advanced degree would be a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the field. Or you can qualify based on exceptional ability if you do not have a degree to qualify you. EB3 is available to professionals, which means people whose jobs require at least a bachelor's degree, and they have the bachelor's degree. Skilled workers, so that means at least 2 years of education, experience, or training are required, or unskilled workers, where less than 2 years of training or experience are required to do the job. So any of these categories, an employer can choose to sponsor, an employee for the green card. So, company sponsorship, involves the employer actually performing the process of sponsoring the green card. So that means that the company is really very heavily involved in the process. We'll talk a little bit more later on in the in the slides about kind of who's allowed to pay the fees. But it's important to note that if you're going to engage in this process, you want to make sure as the employee that you and your company are really on the same page, since you'll have to work closely together during this process, and the company has control over a very significant portion of the process. The PERM is a three-step process. So first is the actual, filing of the PERM, which is generally the longest process. Then there's the I-140 and the I-485 or consular processing. So looking at each of the steps in the PERM, one of the first things that you have to do is figure out the job description with the employer. And, for the PERM, most employers will need to do some adjusting of their job descriptions because most job descriptions are drafted for ideal candidates, whereas in the PERM, the company can only ask for the minimum requirements to do the job in a reasonable manner. So whereas in a normal job description, they might ask for, a great team player, great communicator, or they might ask for a really excessive number of years of experience. As an ideal candidate, they might say, 5 years required, ideally 7 years. But in the actual PERM process, they need to kind of whittle down those requirements to only include the minimum requirements to do the job in a reasonable manner. So part of the process will be working with the employer to draft a job description that is PERM compliant. Then you can file for the prevailing wage. The prevailing wage is you submit the job description and job details to the Department of Labor. They will review it and then they will assign an occupation code to the job. You can make a suggestion, but ultimately the Department of Labor will decide what the code is, and they'll also decide what level it is. And that level will tell you what is the actual, wage that must be paid when the person receives their green card in the future. So if the person is currently working for the company and the prevailing wage comes in and it's much higher than their salary, that's okay. The wage, but the company needs to be willing to pay that wage once the employee gets their green card in the future. So once the prevailing wage is agreed on, that's when the company can start the recruitment process. And the recruitment process is generally going to be, somewhere between 60 to 75 days. And during this process, the employer will place ads. If it's for a professional, a professional EB3 or an EB2, then they'll need kind of 6 forms of advertisements that are, mandated by regulation. If it's for a job that's skilled workers, doesn't require a degree, then you can only post 3 different forms of ads, which are, again, mandated by regulation. So the employer will work with the attorney to post those ads to make sure that they comply with the requirements. During the recruitment process, the employee is not allowed to really be involved at all. The employee should, is not permitted to review resumes, is really not permitted to kind of be involved in any sense of the word. This really is something that should be happening with the company, with particular employees who, often the human resources department, if there is one, who are kind of running the recruitment process, who are reviewing the resumes, bringing in, managers that they need for the actual interviews. If during the process, the company does find a willing, qualified, and available U.S. worker, the process does have to stop. It means you cannot go ahead and file the labor certification because they've tested the U.S. labor market and they have found a U.S. worker who could do the job. That doesn't mean the employer has to hire that worker at all. It just means they cannot proceed with the PERM process at that time. They could potentially stop the process and then try again in 6 months. If we assume that no willing, qualified, and available U.S. workers were found, then the company and the attorney will work together to put together what's called an audit file, which is proof of all of the recruitment that the company has done, and they'll file a labor certification with the Department of Labor. There are certain things that are audit triggers. So when you file the labor certification, it can be certified, it can be denied, or it can be audited. If it's audited, then that means that the government will ask for additional documents, and you'll have 30 days to provide those documents to show that you meet all the requirements, for filing the PERM and that it should be certified. Often During an audit, they'll want to see resumes. They'll want to see kind of detailed evaluation sheets explaining why any particular applicants, were eliminated, why they didn't meet the requirements, and why they couldn't be taught the requirements through a reasonable period of on-the-job training. So, an audit is going to be a very close look at everything that was done during recruitment. And it's important that, the attorney and the company have worked together to create a really solid audit file to respond to those requests. Certain things are audit triggers. So if you require a foreign language, that's something where they're much more likely to audit your case. If you require experience or education that's kind of far exceeds what is normally required for this particular type of job, that's something that they could question as well. Sometimes they also go through kind of trends about what types of cases they're auditing. So sometimes they went, a few years ago, they went through a trend where they audited a lot of unskilled workers cases. So sometimes it's just, the trend of that particular year, whether or not your case, will get audited. In terms of timing of the PERM, right now, it's taking much longer than it used to, or it has at various times. So because you're dealing with a lot of different agencies and they each have their own timelines, that can make it a lot longer. So even to get the prevailing wage right now is taking about 8 to 9 months. So that's 8 to 9 months where you're just waiting before you can even do the recruitment. Once you do the recruitment, that's, a minimum of at least 2 months. Then you're waiting for your PERM to be certified. That can also take, right now it's taking about 9 months. So, already that you're looking at 20 months just for that particular part of the process. So it can take quite a while. Our hope is that the processing times will improve, but right now, post-COVID, this is where they currently are. So, once we get past that PERM, if the PERM is certified, then you get to the I-140 stage. The I-140 stage is much less onerous, on the company than the PERM stage is. At that point, you're really putting together proof that the employee meets all the requirements of the job. So if the job said you need a bachelor's degree and 2 years of experience, when you file the I-140, you'll file with proof that the employee applicant has the bachelor's degree and those 2 years of experience. You also need to file with proof that the company can pay the prevailing wage. So this is going to take the form of tax returns, audited financial statements, or if the company is large enough, they may be able to have the CFO or other type of financial officer write a letter confirming that they have the ability to pay the prevailing wage. Once you, get the I-140 filed, if that is approved, and then an immigrant visa is actually available to you, you can go ahead, and file if you're living in the US, the I-485 green card application. So when we talk about timing, if there's an immigrant visa that's already available to you, then when your I-140 is approved, you can go right ahead and file the I-485, or you could file it concurrently with the I-140. If your case is not what we call current, so there's, that means there's not an immigrant visa available to you. And so that means that you'll be looking at the priority date, which is listed on your I-140, and waiting for your case to become current. So once the date on your priority date on your I-140, is current based on the US visa bulletin, then you'll be able to go ahead and file your I-485. Family members can also apply at this stage with you. So, if your spouse and unmarried, children who are, under 21 can also apply with you, for the green card. All right, so looking a little bit more at, the green card process, particularly either adjustment of status, or consular processing would be the other option. So the procedure for adjustment of status is that you are going to file an I-485 with U.S. Citizenship and Immigration Services. The benefits of the adjustment of status are that you have the ability to remain in the U.S. while the I-485 is pending. You also have the ability to file for work and travel authorization. At the end of the process, most applicants will have an interview with the USCIS officer where they'll ask questions about kind of your admissibility. They'll likely also want to see a letter from your employer confirming that there's still a full-time job offer in the PERM position. For the PERM, that's very important. if the location is to change, if the job title or the job duties are to change, those things can have an impact on the PERM. So that all needs to be discussed with your employer and the attorney well in advance to make sure there's not any issues at this last stage of the process. The I-485, it can take, several months up to and over a year sometimes to be approved, because the timeline will depend often on the timelines at your local field office, which really vary widely across the country. However, you do have that ability to remain. So if you're on an underlying visa and you're not able to renew it, the pending I-485, along with the work and travel authorization you've applied for, should allow you to stay in the US and work and travel relatively normally until your green card is granted. One thing to consider, though, is when you file the I-485 and then you file for work and travel authorization, the work and travel authorization can each take several months to be approved. So if you're not on an H-1B or you're not on an L visa, you want to be in a position where you can stay in the United States for several months before you file your I-485. Because if you're not on an H or L, you won't be able to travel, internationally after that's filed. You'll be considered to have abandoned the petition. All right, so let's look at consular processing. So there's, many different reasons why people, may opt to consular process. Perhaps they, need to travel internationally very, very frequently. Perhaps they, the entire family needs to be, mobile and travel internationally. Perhaps you're not currently living in the United States. You worked here previously, and this, PERM has kind of, been pending for a long time. So there's many different reasons why you may choose to consular process. If you do, the process is that once your I-140 is approved, that approval will be sent to the National Visa Center. They'll send a welcome email saying they've received the case and it's ready to proceed, and they've assigned you a case number. You'll then complete what's called the DS-260 and submit supporting biographical documents to the National Visa Center, such as, passports, birth certificates, marriage certificates, divorce certificates, and police certificates from anywhere that you've lived, for more than 6 months after being 16 or older. So once all those documents are sent to the National Visa Center, they'll review them and they will reach out once they consider your case to be complete. They'll then let you know that your case has been sent to a U.S. consulate abroad and you'll be scheduled for an interview. Generally where you live abroad is where they'll schedule you for that interview. So you'll attend the interview at the consulate, and then if the immigrant visa is approved, you'll receive your passport back with the immigrant visa in it and a sealed packet. When you enter the United States, you'll present that sealed packet. You'll get a stamp in your passport that shows you as a legal permanent resident, and then your green card will be mailed to you, a few months later after you enter the United States. So that's kind of another option. People will often ask, what's better? Is it better to adjust? Is it better to consular process? And if people are living in the US, they will really very often choose to adjust status. There are some statistics that show that, EB cases abroad at consulates have a higher denial rate, than cases in the United States. It's not exactly clear what the reasoning is for that. But I think very often what happens is if you are working in the United States such that a company wants this employee enough to actually sponsor them for a green card, there's going to be some additional questions as to why potentially you're processing abroad. As for most people, they're living in the United States full time, and that's going to be the path that they choose, is to adjust status as opposed to going, to the consulate. All right, so let's talk a bit about who can pay for green card fees. This comes up a lot. So fees related to the PERM process, legal and other fees, just have to be paid by the sponsoring employer. It is also not, it doesn't work to have the employer write up an agreement that says, that you will have to repay them for this, for the PERM. They cannot seek or receive payment for any activity related to obtaining the PERM So that's something to keep in mind is if you have an employer and they say, yeah, we can go through this process for you, but you have to pay all of the fees, that's not going to work for, for PERM purposes. The company has to be okay with, paying for the PERM fees. For the I-140 and the green card petition, that can be paid by either the employer or the employee. So that may be the case where if they pay for it, the employer may pay for it up front, but want some type of reimbursement or something like that, depending on how long the person's with the company. For that, there's more flexibility for the company and the employee to work out an agreement, but for the PERM, that's very clear that you're not able to. The employer is not able to accept payments from the employee for the PERM labor certification. All right. So talking a bit about dual intent, and dual intent comes up when you're applying for a green card because it's important about entering the United States. Whenever you enter the United States, on a non-immigrant visa, like an F1 or a TN, it's important that the border official, does not believe that you're intending to adjust status or to live permanently in the United States. When a visa allows for dual intent, it's the concept that you can be in the US on a temporary visa, like an H-1B, and you're still permitted to apply for a permanent visa, the green card. So it means that if you're traveling in and out on an H-1B and you have, a PERM petition pending, or you have an I-140 pending or approved, or you've even applied for a green card, there's not going to be any issues about your intent. Whereas if you have a TN, once you have an I-140 filed, it's going to be very difficult, to try to renew that TN because if they can see that you have an I-140, which is an immigrant petition approved for you, they're going to have questions for you about what your actual intent is in the US. Do you intend to come in and adjust status? And on the TN, that's not permitted. So, the clear dual intent visas are the H-1B and the L. There's also kind of some more quasi dual intent visas like the O, the E2 as well. Those are ones where it's less clear, but generally the way that the government will treat that visa is if you have an I-140 pending or approved, that doesn't prevent you necessarily from renewing your application or renewing your visa. It's just something that you may have to discuss with them in terms of your plans. And you may choose to check, consular processing on your I-140 to help, them feel comfortable that you don't intend to just come into the US and adjust status if you're on a visa that doesn't kind of permit for that. In terms of whether or not you can ever adjust status when you're on a visa like a TN, you can. There's nothing, you're not prevented from adjusting status while you're on a TN. It's just renewing the TN at a certain point is going to be difficult. But if you've been here, let's say you've been here on a TN for a year, your company now wants to sponsor you, they go through the process, you haven't left, you're here. And they say, look, now we want to adjust, we want to file your green card application. You can do that. That's possible to do. So it's okay for kind of your decisions to change in terms of your intent. Your intent is going to be assessed kind of at each entry. So if at that particular entry, you don't have immigrant intent, it's still okay to come in. The fact that in the future you may, doesn't prevent you from entering on that particular, entry and showing that you really do have non-immigrant intent at that particular entry. Things you wouldn't want to do, however, are things like entering the US on a TN and the next day filing your green card application. That's something that's going to be frowned on. All right, so let's talk about timing and underlying visa status. So when you are applying for a green card, when you're going through the PERM process, you always want to consider how much time is left on your current underlying visa. As we discussed in the previous slide, some visas are much harder to extend, or are subject to more scrutiny once an I-140 or green card petition is filed. So you want to kind of work with your employer and your attorney to see, okay, before we file this I-140, should I go get my, my visa application renewed so that I have, if it's a TN, for example, if I have a 3-year visa, I'm going to get that renewed. And then, after some time passes, we'll file the I-140. So you want to kind of just think about that with your employer to make sure that there's, not a break in work authorization as much as possible, during this process. Also for H-1Bs, if you're running out of H-1B time, if you're almost at the end of your 6 years, and, like at a certain point, in the PERM process, if certain things have been filed or have been pending for 365 days, you can get another year extension. Or if you've gone through the process, you have an approved I-140, but you're not able to file your green card application because of, backlogs in your category, then you can get an additional extension. So you want to kind of consider your underlying status, to make sure that you're covering yourself, and filing the PERM early enough to make sure that you can either, get an extension if you need, or file the green card application that early enough that your work authorization, card will come through and allow you to work even without an underlying visa status. Do you want to adjust status in the US or get the green card through consular processing? That's an important thing also to discuss with your employer and with your family, just to determine with your employer, if you're doing consular processing, maybe you need to spend some time outside the US, how are they okay with that? For your family, if you're adjusting status, are they okay with not leaving the United States? If you're not on H&L visas. So important things to consider before you file. And also with your family, you want to consider, do you have children that need the green card? And, how old are they? Because at a certain age, they will age out. So kind of if you have children and you think they will want green cards in the US, kind of the earlier that you can start, the better, to avoid them aging out at 21. When we talk about kind of green card interview considerations, before you go to your actual interview, you want to review, of course, your immigrant visa petition and your green card petition. So your I-140 and your I-485 that were filed, you want to look at those and make sure you're familiar with all the information in them. Organize and print your documents to bring to the interview. Make sure you have all the required original documents they want to see and a copy in case they want to take that documentation. You'll get an interview letter that has a long list of documents you need to bring with you. And you want to kind of follow that list to make sure that you're not getting approved or the approval delayed because they need to see a document like the original birth or marriage certificate. Bring your I-693 medical exam sealed, ensure it's not expired. You also want to get updated proof of employment from your sponsoring employer. So you want to have a letter from them that goes over kind of, what the job is, that the job offer is still good, just confirming everything that's in the PERM. You want to make sure the job is in the same location as well. So, for the PERM, it's location specific. So if if you did the PERM and you tested the labor market in Florida, and now your position's been transferred to Texas, that can be a really big problem. So depending on how long your I-485 has been pending, that may be a big issue that would require you starting over. So you want to make sure that you're kind of discussing all of that, with your attorney ahead of time. If the job has changed significantly, if there's been a change like to the location or to the job duties, you want to look and see if you can utilize something called porting. So that's a case where if the I-485 was pending for 180 days or more, and the job is in the same or a similar occupational classification, you may be able to do something called porting, where you can still utilize the approved PERM, even though there has been, a change such as, the job is in a different location. You also want to bring any proof of maintenance of status if you're going to a green card interview with USCIS. So you want to show that you've, never violated your status at any time in the United States. That being said, if there have been some status violations, you also want, maybe you had a couple days where you stayed past your I-94, or you were changing jobs between H-1Bs at a time there wasn't grace periods, and there was a few days where you were out of status, that would prevent you from adjusting status. However, under the EB2 or EB3 categories, you can utilize something called 245K, which means that as long as you have, they'll only look back as far as your most recent entry to the United States. So if you haven't violated your status or worked without authorization within, for 180 days or more within your last entry, you should still be able to adjust, even if there's a few issues in your immigration history over time. You should also, have a meeting with your immigration attorney. You may also want to do a practice interview either with your attorney or with someone else. The types of questions they're going to ask, they might ask about the job offer letter. They may ask for pay stubs if you currently work there. That's also to show that you're maintaining your status. If you don't work for the company, they may ask, what are you doing in the US? How are you supporting yourself? They may ask some details about the company. What do you do there? Where's the corporate headquarters? They'll also ask questions about the I-485. So may confirm some biographical information, such as your name, your age, your address. They may ask questions about kind of any prior statuses you've held. If there are any kind of security red flags, if there's ever been any arrest or any criminal issues, they'll ask about that and ask to see disposition documents regarding that. Those are all things to keep in mind. You want to kind of run through with your attorney, especially if there's any issues, criminal issues or status violation issues. You want to kind of discuss how you're going to address that, whether you need to carry any specific extra documents with you. Also, if you are applying with your spouse and your children, it's a good idea to bring, a few documents just kind of showing the relationship with your spouse, to help show that this is a valid marriage. So birth certificates of your children, if you have kind of, joint like mortgage documents, if you live together, you have a joint lease agreement, joint bank statements. It's generally not a large focus of the interview, but sometimes officers do want to make sure that there's no, that the marriage is a valid marriage and is not one that was entered into just for immigration benefits. All right, so let's talk a little bit about porting. What is porting, and how can you use it to change employers, during the PERM process? Porting allows employees to change employers once your I-485 has been pending for at least 180 days. And the I-140 does, for the I-485 does have to be approved. You don't have to have, the benefit of porting is that your new employer does not have to complete a new PERM or a new I-140. So at most stages of the process, if you, let's say you're doing a PERM with one company and you change employers, that new company is going to have to start all over. There's nothing you can kind of use from the first PERM. However, if you've reached this stage of the process, you have an I-485 pending, it's been pending for 180 days. Now you're in a position where you could change employers with a bit more ease. So your new employment, though, must be in the same or a similar occupational classification as the job that was offered to you in the Form I-140 that was the basis of your green card petition. So you cannot kind of completely pivot, and do a completely different job. It needs to be in the same or a similar occupational classification. So to establish that your new position is the same or similar occupational classification, you can submit evidence to the department, regarding particular occupational codes. There's lots of information on kind of what they call the ONET or the Bureau of Labor Statistics. You kind of want to look at what are the specific job duties, skills, experience, training, licenses, certifications needed for the original job, and how does that compare to the job that you're doing? As much as possible, you want to show that they're extremely similar, if not the same. You can look at the wages offered for each job, and any kind of material or credible evidence that you have, just to demonstrate that each of the jobs, it should be qualified kind of as the same or similar, occupational classification. If the job with your current employer has changed and you want to use porting for that, you can. So if you think you're at your particular employer, you have a new job and it's in a similar occupational classification, you can use porting, to continue the PERM with that particular employer. The way that you notify USCIS of a request to port is you file something called Form I-485 Supplement J with details of the new permanent full-time job offer. Unfortunately, if you request to port, you kind of need to proceed with that application. If USCIS denies you, then you would need to start all over with a new PERM application, if the porting application is denied. So this is a very common question. Can you change employers after you get your green card? When you get your green card, you are at the interview, or even when you're, submitting the documents, making a good faith attestation that you intend to continue working for the company that sponsored you. The company as well as making that attestation that they intend to continue, employing you. That being said, there is no requirement that you continue to work for this employer for the rest of your life. Let's say that you work for this company and then after 6 years, you get another job offer, and you leave, likely there's going to be kind of no issues with that. The place that this comes up is during the naturalization process. So when you are applying to become a U.S. citizen, they will look back at the basis for you becoming a green card holder. So if, you got your green card on the basis of a job, and then, 1 month later, after getting your green card, you left that job, that's likely something they're going to ask about. And if they felt that there was any kind of fraud implicated, or perhaps you hadn't been truthful, that you really intended to work for this company, that could be a major problem, at that point for your green card application. I mean, for your naturalization application. And they could also, dig into whether, the green card application, should be still considered valid, given that, they may find that there was fraud. So in that sense, you do want to kind of have in your history showing that you've worked for this company, that you had good faith, to work for this company at the time that you got your green card. And if there was something that happened where you had to leave that company, let's say, that there's a kind of an explanation that makes sense. So, you got another really lucrative job offer you weren't expecting, your spouse needed to move to another, state for work, whatever it is, there should just be an explanation, that makes sense, so that if you are asked about this at your naturalization interview, it's, it's clear that there was kind of no fraud, in obtaining the green card to work for this employer. All right, so we have reached the end of the presentation. We do not have any questions, so thank you all for joining, and I hope everybody has a wonderful day.